All right, well, welcome to our event, Insights from Industry, Intellectual Property and Patent Law Careers in the Life Sciences. I'm Elizabeth Wu. I'm one of the co-founders of Scismic, and I started my career in research, actually, and noticed how challenging it was for scientists to find jobs that really fit their specialized skill sets. And in addition to that, I also realized that a lot of universities and training programs don't really expose or teach their trainees what other career options there are outside of academia. And so this is something that my co-founder and I felt really strongly about, that there are so many ways that life science expertise and the training that you go through can be applied in different careers. And we wanted to make that more accessible and help bring awareness to all the other careers out there for life scientists. So my co-founder and I started Scismic. Essentially what we do is we run career development events for life scientists, and we also provide a job matching platform that allows scientists to see what jobs they qualify for that they might not even have thought about. And so they can actually, if you go onto Scismic, you create a profile, you can see what jobs on Scismic match to your skills, and perhaps it's something that you haven't even considered in your training. So as I mentioned, we run a lot of different career events. We have events on how to tailor your CV for industry jobs. One of the most well-known career paths is going into industry research. And so we have a lot of events around what to expect during the interview process, what hiring managers look for in biotech startups and big companies, differences between academia and industry research, and so on. With Scismic, you can see exactly how your skills can be applied to jobs that are in patent law, in industry research, even in business development and marketing or scientific communications. So this is something that if you have any questions about, feel free to message after the event, and I'll give you the contact information at the end of the event. So before further ado, I want to introduce our panelists today. Today we have Daniel Young from Wolf Greenfield, Meng Zhang from Wilson Sonsini, and Andrew Mathis also from Wolf Greenfield. And I discovered that Andrew and Dan are actually office neighbors. So it's a small world. And so I'm going to turn it over now to the panelists to introduce themselves. Dan, can we start with you?
Sure. Yeah, my name is Dan Young. I'm a patent attorney at Wolf Greenfield. I'm a shareholder in the firm. I've been here for coming up on 17 years. Initially coming in as a technology specialist and patent agent, as Andrew has experienced, and going to law school at night and becoming an attorney, and then continuing on, and started as shareholder in 2018. So my background is somewhat mixed. My undergrad is actually in marine engineering, and I worked for a bit in the maritime industry. And then from there, worked in an engineering research lab for about another 3 years, during which I started going back to grad school for biomedical engineering. Got a master's, then I sort of transitioned into bio, ultimately doing a PhD in focusing on cell biology, molecular cell biology, really kind of driven by the science. It's somewhat of a longer story as to how I went from marine engineering to cell bio. But when that was done, I was at a place of, I think, originally thinking I would go back to industry and not have a science career, but I really enjoyed academic research and academic work, and decided then to do a postdoc, which I did. I was a postdoc at Novartis and Harvard Medical School. And that gave me an opportunity to sort of see both sides of things, to sort of see how research happens at a pharma company and kind of understand the drug development process, which I found very interesting at that time, and then also kind of be in a cutting edge lab that was developing tools that were being translated to pharma. And during that period of time, I was still exploring career opportunities and met one of my now fellow shareholders at an event, job fair at Harvard, outside the lab that I was in. And I had an experience with patent law as an inventor in a few instances, so I had sort of been aware of it and intrigued by it as a potential career option. And when I met with Marianne Trevison, who's a shareholder at Wolf Greenfield, when I met Marianne at this event, I just sort of she's a great person and has a lot of energy, and she sort of drew me in. I think I already had the inclination, but meeting her kind of solidified that. I came in, I had actually ending my postdoc midway through. It was a productive postdoc. I had a great experience, and in some ways it was hard to leave, but I think there was something about this opportunity that I knew was for me. And I really haven't looked back since. So I've been doing it ever since. And that was around 2006, 2007. So maybe I'll leave it at that and turn it over to whoever's up next.
Thank you, Dan. Ming Ming, could you please share a little bit about your background?
Yeah, sure. Very nice to meet you, Dan and Andrew and everyone else in the audience. I'm Meng Meng. I'm an associate in the Boston office of Wilson Sonsini. Very happy to be here, and really happy and surprised to see so many scientists trained as scientists are interested in patent law. So I kind of had a similar career path as Dan. I was hired as a scientific advisor in Wilson and went to law school, passed the bar, become a patent agent. I went to law school while working during the day at Wilson. I've been here for 7 years. 2 weeks ago, February 14th is actually marked my 7th anniversary here. So I got my PhD from UT Austin in biochemistry, and then I came to Boston for my postdoc training at Harvard Medical School and also Wyss Institute. When I was doing my postdoc there at Wyss, I got involved with patent drafting, working with in-house counsels, and also went to a workshop actually held by Wolf Greenfield talking about patent law career path. That's how I got really interested into this career path. And then after all those years, I'm here right now. Very nice to meet you.
Thank you, Meng Meng. Andrew?
Yeah, I feel like I'm gonna share a very similar story as my two colleagues, but perhaps just not quite as far developed. So I'm Andrew Mathis. I'm a patent agent at Wolf Greenfield. And just that means that I passed the patent bar. I can practice at the United States Patent Office, but I'm not a lawyer yet, though I'm in night law school doing that program, which is pretty common. And I've been at Wolf 4 years this summer. And similarly, I was in a PhD program doing cell and molecular biology and really enjoyed that, but also just wanted some more stability in my life. As much as I enjoyed doing science, there was some instability with doing science, and my wife and I had our first child, and it kind of made me reflect on really what I wanted out of a career. And so after some digging, I ended up in patent law. Yeah, really enjoy it. It's a fun career.
Thank you. Andrew, my first question is for you, actually. You mentioned you're looking for more stability when you were considering career paths, and that's why you ended up in IP. Can you share a little bit more about why you chose IP? I know you explored different career paths. What stood out to you about patent law?
Yeah, so this story is kind of interesting. I started looking, and I think I looked in industry. That's a place to look. I thought about being an analyst and working for like a government agency like the FBI or something like that. And that didn't really fit. And actually patent law was on the very bottom of my list. Like I knew it was a possibility, but I just thought, like looking from the outside in, that it'd just be a boring thing to do. But I wanted to look at it because nothing else was interesting to me. And so I had some friends who were attorneys and asked them if they knew any patent attorneys and just started talking to people. And as I talked to people, I found out almost I think really like 19 out of 20, I talked to a lot of people, were happy with their careers. There was one person who was a little more questionable, which I thought, like, that's pretty good numbers. And I also started learning about patent law. So I picked up like a book at like a used bookstore about patent law and started reading it. And so that's the path that took me down here. And really the reason why I ended up in patent law is my thought process was, well, like I know it's a stable career, like from talking to people, which is one thing I was looking for, and I wanted to know if it was interesting. And that's why I talked to a bunch of people and also got a book about patent law and literally just started like reading about the law to see if I thought it was interesting, because that's one of the reasons I did science, is because it was interesting to me. So I knew I needed something else that would interest me.
And what specifically excited you most about patent law?
I think what was interesting to me is, one, that it's complex. It's not something with like plug and play rules. There's a lot of analysis in it. And part of it is a lot of the ideas in patent law are like kind of familiar to scientists, but under new terms. So when we think about like when you're developing like a new project you want to do in the lab, you're thinking like, has someone done this before or not? Because if they have, maybe my project wouldn't be very interesting. Or like, is what I'm doing not really that interesting compared to what other people have done, which kind of reads on obviousness in patent law. And so as I started reading these things, I saw these parallels where like my experience thinking as a scientist also impacted, was like similar to what I was reading in the law, but the law provided like a foundation of what does it really mean for, you know, something to be patentable. And so I think that's part of what really piqued my interest. But part of it really was, as I read about it, I was like, oh, this isn't like simple. This is interesting. It requires analysis and time and thought, and there's not necessarily a right answer. And all of that appealed to me. So
Thanks, Andrew. I wanted to add for the audience, if you have any questions while the panelists are speaking, or any questions that you came in with, feel free to put them in the chat. We will have a Q&A at the end of the session. So Meng, when we spoke, you had mentioned, for those in the audience who are, you know, thinking about transitioning, on the verge of transitioning, or perhaps just made that transition into IP, you mentioned when you had first joined, you were surprised by some of the cultural difference between you working in a lab in a university and working in a law firm. Can you describe what those differences were?
Yeah, sure. Yeah, it is quite different. I think the big difference is, as I said, more hierarchy in a law firm. I think part of the reason I felt that way is I had not worked outside of a lab before I joined Wilson. So joining Wilson is my first official job and might be my last one. I think hierarchy probably exists in every working environment in the industry. So if you are moving from a biotech company or big pharma to a law firm, the impact may not be that prominent, but going directly from a lab to a law firm, which honestly might be the most hierarchical organization among all organizations, you do feel acclimated to the new environment. I think the other part of the reason may be that the hierarchy is much needed to get things done in companies or law firms. So it's not necessarily a bad thing, right? Too much hierarchy is bad. Too much hierarchy to the point that persons on lower rank do not feel well respected. That would be really bad. But some hierarchy may be necessary to just push to get things done. When we were working in the lab, you know, we were self-motivated to graduate, trying to get out of there earlier. We were initiating projects, discussions with colleagues or advisors, trying to solve problems, and less emphasis on seniority, right? We usually freely discuss scientific problems and don't really care if we point out other people's are wrong, even to more senior people. Especially a lot of scientific questions are very objective. There is a right or wrong answer to that. But in law firms, less freedom, especially for new hires. You'd better talk less and observe more, right? And a lot of questions are subjective. Even, the rules and laws are man-made. So you would be expected to listen to more senior people who has more experience, who has dealt with similar situations more, or who knows more. So in some cases, you just need to follow the order, right? That's hierarchy, without being given a chance to know why, if the rationale behind it is too complicated to grasp at the time, or there was no time to explain at the time. And such hierarchy would be also increase efficiency, I think. That's just the nature of how things are done in law firms.
You had mentioned that IP professionals have seen a lot of cases and have seen a lot of, through their experience, they've seen a lot of different situations where, even if you might not understand why as a junior patent agent, potentially why certain decisions are made, their experience has kind of informed them that, what is likely to go through, what is likely to succeed, what strategy is likely to succeed, and what is likely not to succeed. I believe you had put it in those terms when we had spoken last. Okay, so thank you, Mengwen. And Dan, my next question is for you. How do you think scientific research and patent law are similar? How have you applied your scientific training to this field?
I feel like Andrew touched on this in a nice way. I think scientific research is different in certain respects, but I think that, stepping back, what we do, we sort of have to understand a framework within which companies can operate in relation to patents and obtaining patents. And a big thing that comes up is sort of understanding the risks that companies can face and that within that framework. So in that, there's sort of just a good degree of research that one needs to engage in, which is similar in the sense of science. I mean, when you're entering into science, that particularly if you're engaged in research, you sort of have a basic understanding of nature and the way that things work, and with that basic understanding, you can formulate hypotheses and then conduct research to get you to that hypothesis, and then engage in sort of testing and experiments to evaluate the strength of the hypothesis and so forth in order to make judgments about the way that nature works. We're not dealing with the same thing in law, but I think the sort of the training that you get when you engage in that kind of a process is very helpful when you're working within the legal realm. And I think scientists tend to do quite well when they make the transition, because you sort of understand how to navigate within a framework, how to formulate questions, and how to kind of explore and test hypotheses that you might generate within that. I'm being somewhat abstract, but I think that there's sort of a level of skill set that a scientist has that translates very well to the legal world. And maybe just getting more specific, a lot of what you do draws on your scientific training at a very specific level, in the sense that you're dealing with inventions that are rooted in science, and you're interacting with folks that are engaged in science. And, part of what you're doing when you're interacting with those folks is sort of trying to understand that science and trying to understand the limits of that science, and then trying to kind of, from those insights, envision in this legal context what one can do with that information to either create a patent right, for example, and there's a process for that we'll probably get to, or to help companies that are engaged in that kind of research understand the extent to which that they might face patent risks if they're to proceed with that science. So I think that it's an interesting question. I remember when you asked it before. It's sort of, I find it as being an interesting way to frame the question. I think maybe a takeaway though for everyone on the call is that if you've sort of developed your scientific thinking sufficiently, that the skill sets that you've acquired through that translate very well in the patent law realm.
You had said something I thought was really beautiful during our call, where you said, in science, in research, you're kind of exploring the boundaries of like the natural law, right? The physical and scientific laws, and figuring out what is happening within those boundaries.
Yeah.
And then IP law, you're kind of doing the same thing, but it's with sort of, what are the legal.
Yeah, you are. I think I'm glad you said that, because I didn't know it came across that nicely when I said it the first time. But I think I was trying to get. I think your question got me to this place of like, what is the fundamental level at which engaging in scientific research and engaging in patent law are really one and the same. And sort of it took me to kind of drawing parallels between a legal framework that is sort of man-made, as Meng had pointed out, and the framework of nature that, in both cases is sort of, to some extent, a law, and we have to kind of operate within that framework. And in both scientific research and sort of natural law, we only have, in some cases, a rough understanding of what that law is, and how things can function within that framework. And it's true also in the legal realm. Ultimately, laws are expressed by humans. It's sort of an attempt at expressing a concept that we believe is an appropriate way for companies to act within this realm. And we're limited in the way that we can express it, in the words that we use. And so it leaves a lot of room for interpretation. And then when if you're a company trying to make decisions that maybe get to the limits of our understanding of the law, it requires sort of testing of that law based, maybe perhaps an analogy, to sort of make judgments about whether or not you're going to run afoul with the law, or how to structure things within the law to ensure that you create the best patent, for example, for an entity. So there is a level, I think, at least I would argue, that where there's this sort of similarity, and that's separate from just the skill set that you get when you engage in science, which I mentioned as well. The skill sets that you get, functioning in that scientific world translate very well in the patent law realm. A specific example that I've done a lot of these kinds of sessions over the years, and I enjoy doing them. But one analogy that I always felt was helpful, which is maybe a practical one. It doesn't get to the kind of this more abstract way of looking at laws, but it was sort of the, just understanding what is it like to sort of get a patent, and what have you maybe practically done as a scientist that's a good analogy. And a good analogy would be if you published a paper, you've developed a manuscript that outlines your thinking on a particular scientific subject, and it's backed up by evidence and experiments, and you submit that to a journal, and then you engage in a process of review with the journal where you may get feedback and questions from the reviewers, from the editors, that you have to then address, and sort of there's this back and forth that you have with them, and to some extent a negotiation over what would be an appropriate set of experiments to do to clarify a particular aspect of the work that you've done. And this sort of process ultimately matures into, hopefully, an actual publication. Patent process is somewhat, there's a lot of analogies there, because you're sort of drafting a document, which is a patent application that sets forth, what your thoughts are on what an invention is, and then you're submitting that to the patent office and engaging in a sort of back and forth with the patent office, in a sense of negotiation over, the scope of rights that you're entitled to. And so there's a lot of skills in both areas: the writing, the thinking, the framing, the telling of the story, the negotiating that you do as a scientist in that sort of publication setting, that I think translate very well to the legal realm, to the patent realm, in terms of actually procuring patents.
Thanks, Dan. All right, switching gears a little bit, I have a question for Emma. You started out as a patent agent, correct? And then went to law school, and you're now an attorney. Can you share a little bit more about how you decided to go to law school and the pros and cons you considered during that process?
Yeah, sure. Yeah, I went to Suffolk Law evening program, just a full-time work during the day, part-time law school. So it's a 4-year program. Going to law school was not a difficult decision for me, actually. So not going to law school never came to my mind as an option when I decided to go to this career path. I did spend some time deciding whether I go to a day program or evening program for family reasons, and I finally chose the evening program. That being said, there is a career path for people who decided not to go to law school, or for whatever reason, personal reasons, that you cannot go to law school. At least at Wilson, we have 5 different tiers for patent agents, from junior agents, intermediate level, all the way to senior level, and eventually patent counselor position, which is a very senior position, and then the salary is based on negotiation. So if you're happy about such position, no need to go to law school. You still have a pretty successful career. Salary may not be that high as a partner in a law firm, but you will suffer less, definitely. And people will see you more in the office, see you more at home. All that's the benefits without going to law school. Going to law school, I think you would learn new things, right? The laws that you were never exposed to before trained as a scientist, and also exposed to new people with various backgrounds, not just the scientific background. I had classmates who were high school teachers, who was in military before, all sorts of jobs that people do during the day, and also open more opportunities for you. Let's say if you suddenly not interested in patent prosecution, you could become a litigator, right? You could do technology transfer or corporate laws, or even family laws, criminal laws, I don't know. But with that law degree, you have more opportunities, more options, higher salary, more leading roles, and of course, more responsibilities. So if that's what you aspire to do, then just go for it. I would highly recommend for people who are actually decided to go to law school to go earlier rather than later, because I think as people get older, more things will come out, more things to worry about, especially on the family side, especially when you be married, getting married, having kids. You will have less freedom to make decisions just for yourself at that point. So if you decide to go to law school now, I think it's really good for your career. Just go ahead.
Thanks. And has your firm supported law education, or do you know that if law firms support law school education for their employees?
Yes, I believe, at least in Boston, most of law firms do support law school education. That's really good. You just financially helps a lot. Like, for example, at Wilson, we have a program called PALS. It's short for Patent Agent Law School program. It supports 100% tuition for evening program. In other words, you work full-time, go to law school part-time, and 50% tuition for day program if you go to law school full-time and only work part-time. For part-time law school, the salary is not reduced because you work full-time, but if you're going to law school full-time, the salary, of course, is also reduced to 50%. And the nice thing about the program is that the required billable hours are also reduced. To those who don't know, in law firms, you have to reach certain billable hours per year. That translates to maybe 7 to 8 hours per day working hour on client matters. So going to law school, definitely your requirement will be reduced because you need to find time to study. I guess besides the financial support from law firms, I think I get also emotional support from my colleagues. Usually I tell people if I have classes to attend or exams to prepare, we can always find extra helps who can handle your projects. So that's really, really good. I think our firm also supports 6 weeks of bar leave. That's the bar exam you have to do after you graduate and become before you become a real attorney. It's a very important exam. That's the last hurdle you have to overcome before you become a real attorney. The 6 weeks of bar leave is pretty significant, and then we can request additional days off using our personal days to prepare for bar exam. I think the other support is that if you are working in the law firm in Wilson and then go to law school, you also get 2 or 3 years of bump in terms of salary or seniority. So they do have lots of support for people to go to law school.
Thank you. I also see Andrew nodding a lot, so I'm guessing that Wolf Greenfield also has programs for law education as well. We are coming up to 1:40, which is when I wanted to open the Q&A. I do have a couple more questions, 2 more questions, one for Andrew and one for Dan. So I'll ask those. And if possible, Andrew and Dan, I'm so sorry, but if you could keep your answers into 2-ish minutes or so we can open the floor, that would be helpful. Andrew, so you are now a 4th year patent agent, correct? Mm-hmm. Okay, 4th year patent agent. So in sort of recent memory, you remember what it was like to be a 1st and 2nd year patent agent. For those who just made the transition, do you have any advice or any tips and tricks you can share with people who are on that stage?
Yeah, I think there's a few things. One is, like, you've probably just come out of the science, right? Whether a graduate school lab or a postdoc or an undergrad or industry. And so you might be surprised that you know a lot of science and a lot more cutting edge science than some of your supervisors do because you recently came out. And some people, like Dan, have been out of the lab for 17 years. and a lot can change. And so it can be helpful, actually. Like, it's hard to feel like you have something to offer when you're brand new, because like the law can be big and intimidating and new, and some of it is intuitive and some of it's not. But I think you can always offer like your scientific expertise when you're trying to understand an invention and trying to ask scientists about it and communicating with them. And then I think the other thing I've noticed is that when you join a law firm, your first impressions in terms of like the work product you're making for your supervising attorneys are important. And it doesn't mean you have to get it like legally right your first time in practice. You probably won't. But it does mean that like you should think about it and ask questions and avoid typos and like show you can do a good job and meet the deadlines you set. And I've found that when I did that, and I've seen some of our newer hires do that, that like word spreads, right? Like, oh, this person does a good job, and then more work starts coming their way. I think those are my 2 tips.
Thank you, Andrew. And for the last question, Dan, if you think back to when you started working in patent law and early in your career, is there anything you wish you had known at the time?
I think that the place I would go there is, and I think some of the other panelists have alluded to this, is just sort of maybe reflect, so a little bit more self-reflection at the time on the kind of balance that I wanted in my life. When you make this transition, and I kind of pretty much knew early on that I wanted to, when I made the transition over, that for me it was, I wanted to become an attorney. I wanted to stay in private practice. I sort of gathered that insight pretty soon, and I was, I'll say, all in, to the point of maybe being a little imbalanced with my life, not sort of giving enough room for things outside of work. And so I think what I would say is, come in, there are lots of opportunities, but definitely reflect on the work-life balance piece and make sure you have that toggle set appropriately. And it changes over time, but sort of just paying attention to that early on, and knowing that you can set it at a place where you can kind of, you can get all that you need in terms of training. And when you're in law school, it's tough to find the balance, but you really have to take advantage of it when you can, and just sort of, I'd say, pay attention to that.
Thanks, Dan. All right, so I'm going to go through the questions in the chat. For the panelists, if you think you are well equipped to answer that question, feel free to just jump in and answer. The first question is, what are the differences between working in-house and working for a law firm? Who wants to take that one?
Well, maybe I'll take that one. I spent a bit of time as part of my legal training in a somewhat of a secondment, working as an attorney, spending a certain amount of time at a company, functioning as sort of a pseudo in-house person. So I've not actually worked in-house, but I have some exposure to it through that experience, and then just interacting with others. In both cases, if we're talking about being an attorney, in both cases you're acting as an attorney. You're sort of representing, in the case of inside counsel, you're representing the company as inside counsel, and there's a lot that you have to think about in that role. Oftentimes as inside counsel, the work that you do sort of can, depending on how big the group is within which you work, it might expand into, you're the only attorney in the company and you're doing many different things beyond patent law. On the other hand, if you're at a really big company, a big pharma company, for example, you might be a patent attorney within a specific business unit, and that's all you do. So there's quite a range of experiences that you might get on the in-house side. Another big difference is on the in-house side has been, we've already talked a little bit about billable hours and tracking time as outside counsel. In companies, I think for the most part, that kind of tracking doesn't happen. I mean, I think that there's sort of accountability and tracking of work, but it isn't at the level of the tracking that you're doing in private practice. So in private practice, you're sort of the what you're selling is your time and the attention that you put on patent cases for clients, and so you have to track all your time, and you down to, in our case, like every 6 minutes you have to have documented what you did every day all the time. And so there's a lot, that is one thing that a lot of people kind of react to when they think about the differences between in-house and being in private practice. But in I think that they're both really exciting careers. They're both, you're presented with a lot of the same similar challenges and different challenges, and there's a lot of overlap. I don't think one is easier than the other, and oftentimes people who are in-house go there after having spent a significant amount of time in private practice, though that isn't the rule necessarily.
Thanks, Dan. And you had mentioned, going back to sort of the what's your advice of what people think about in terms of balance. You had mentioned that there's actually quite a few different career paths you can take in patent law. Do you remember what those are?
I mean, there isn't a lot of time, but I mean, so in patent law, there are sort of two, particularly in private practice, you can go a litigation route where you're involved in sort of contested matters and enforcing and defending patents, either before the court or some administrative body, particularly the USPTO. And then the other side is where you're on sort of procuring patents. You're sort of helping companies develop strategies for obtaining patents, and in that realm, it's kind of also working more broadly with companies, helping them develop an overall IP strategy that includes both building a patent portfolio around company assets and then also deciding when and how to manage patent risks. And in that realm, kind of the limits there is you tend not to do litigation when you're kind of more in that realm, but you'd interact with litigators. And the paths to getting to the two places, they can be the same, but on balance, they tend to be different. So that it tends to be that, from my perspective, others may have different perspectives, but I think over the years, what I've observed is that people who tend to go down the litigation route know pretty early, and will go direct to law school full time, and maybe do a clerkship after. Typically do that, have experience in that role, and then have done interns or summer associate rounds in patent firms and gotten patent experience, and then come in as an associate into a law firm within the context of a litigation group, and then sort of develop as a litigator. Whereas on the patent counseling and prosecution side, oftentimes you see folks like the three of us who have had some significant science experiences, and then made the transition over into a tech spec role, in which you'd go to law school at night and then ultimately become a patent attorney. And then, from either of those tracks, you could ultimately go in-house. And there are folks in-house who, for example, might manage litigation for a company, and then there are others in-house who might manage portfolio development for a company. So, both paths can get you to, either having a long-term career in a firm or going in-house.
Thanks. So lots of options, even within the field. Okay, next question. Do we have to pass the patent bar exam before applying? I assume that means applying to a law firm. Does it boost your application and increase your chances of getting hired?
I can take this one, and maybe the next few too. I think I can do pretty fast.
All right.
First, no, you don't need to take the patent bar exam before applying. Typically, law firms will pay for you to take it and pay for a really nice course for you to take to get ready for it before you do that. Does it help having it done? Probably a little bit is the answer. I certainly don't think it would hurt you, but it's not required. LSAT prep and doing that. So I think that depends on your target university and what your plan is. So for me, similar to, I'm at Suffolk University. Suffolk's a good school. They have a night program. They're not an amazing school. I didn't need to crush the LSAT. I didn't put in the time to crush the LSAT. And so my preparation was, like a few weeks and not a ton. If you're thinking that you want to go to a really top school and you have reasons for that, you're going to need to do better on the LSAT. Typically, though, if you're going to go to a law firm, you're going to take the LSAT while you're hired at the law firm and not while you're in graduate school. If you go straight from graduate school, you might have to study for it. And time-wise, I think it could be quite a bit. It just depends on your score and where you want to go. So I know that's kind of a washy answer, but I think that's what it is. PhD versus master's. I think typically in our group, we have more people hired with PhDs or MDs than we do with master's degrees, but we have people with master's degrees and they can be great patent attorneys.
And bachelor's as well.
Yeah,
it's interesting that I went to MS, but I mean, I'd say generally on that one, because it may be something I wouldn't want to deter people who don't have PhDs, because there are a number of people who practice that are, top practitioners that don't have PhDs, and it's not a requirement. It's helpful. It's helpful from a, the standpoint of being competitive and having a level of training that can, benefit you in the work, but it isn't necessary. And then I wanted to reflect back quickly on the two tracks, because you often tend to see folks who go the litigation route have not done the PhD or MS. So oftentimes those folks, will do an undergrad degree and then go right to law school. But there's no hard lines on this. I know PhD litigators and master's litigators and BS litigators, and I know BS and MS patent practitioners, and so it runs the gamut. But I'll just stop there.
Thanks, Dan. How long is the interview process for patent agent jobs? And someone is looking for this answer because they want to give themselves enough time to wrap up some research projects. So how long, I guess, how long before you want the job would you start applying for the jobs?
This is probably a quick one. I mean, I think the interview process is not very long. I mean, I think it's, Meng could probably comment on Wilson, but I imagine it's pretty much the same. I think what's maybe behind the question is, do you have room to finish things up? And I think that can be negotiated. I mean, if you get recruited by a firm and you go through the interview process, part of what you will tend to negotiate is a start date. And, part of that might account for needing to finish up like a thesis or something like that. So, there's certainly room to negotiate on that point.
Yeah,
Great.
Okay. Yeah. Sorry.
No, I was just about to turn it over to you if you have anything to add.
Yeah, the interview itself is actually not long, several days of the week, depends on your availability. But I would say if you are thinking about transitioning, submit your resumes earlier, as much earlier possible, and also, attending in recruiting events like this, and or making connections with people who are already in law firms would be a good starting point to get the process going. And then there will be some time for the internal recruiting team at law firms to review the applications. That could take a while. And also after you interview, if you get interview opportunity after you interview, and then if they decided to give you an offer, there will be a chance to tell the law firm, when you can finish your work at the university before you join. So the time is flexible depending when can you actually make the transition. So no worries about that.
Okay, thank you. How do you choose which law firm to work with? So what factors were you considering when you were looking at different law firms?
I can take this as well. I think initially when I was applying, I didn't really choose a particular law firm. I submitted my resumes to several different law firms in Boston. And I happened to know someone at Wilson. That's how I actually eventually got the job. I think meeting someone in the law firm who can refer you is much better than just blindly submitting your resumes. But yeah, you don't need to just stick with one firm. There are lots of opportunities out there, and try different opportunities, I would say.
And do patent agents get opportunities to do IP strategy counseling, or is that only for attorneys?
I can answer that one. I do IP strategy counseling all the time, and I'm a patent agent. You have to understand some stuff to be able to do it, right? It takes some time. You need to understand IP law to be able to counsel and strategy. I will say that if you're a patent agent, you're going to be supervised by an attorney in pretty much all of your IP strategy counseling, because your license might not extend that far, like practically. So you probably can't do it by yourself, but under supervision of an attorney. And I do it. Yeah.
Thanks, Andrew. How do you get the first step into the area without a law background? Is law school the first, or getting exposed to the actual intern and work opportunities the most important to start with? Or is any of it important to start with?
I guess I can chip in on this one too. I did it recently. I didn't have any specific IP background knowledge. My suggestion is to go try to get a technology specialist type position, which is kind of right before you become a patent agent somewhere, and give it a try for a while before you put the investment into law school. Unless you're like 100% sure this is what you want to do forever and you're just locked in. I think one of the reasons I did it the way I did is because if I went and did this for a year and realized I didn't like it, I wanted to be able to get out then and switch to something else, rather than going to law school for 3 years and then doing a year and being like, oh, this doesn't work for me. So I think that path. In terms of getting into it, I don't think a ton of people have background in IP, but some tech transfer offices at universities have opportunities for internships, and some law firms like Wolf Greenfield has some opportunities for internships.
Thanks. And this was partially answered by Meng, but what I do think she talked about some of the unexpected transitions between sciences to law. What was the most enjoyable, rewarding part about being a patent lawyer?
I think to me is the success of my clients. You know, especially if you are involved with the client from the very early on, like a startup company, there may be only 1 or 2 persons initially reaching out to law firms, and you help them build up from the ground up of their IP portfolio, of their platform technology, and then eventually they are acquired by big companies or IPO. That's really exciting and rewarding for me. And then during the day-to-day job, I think the small rewarding part would be, get cases allowed from patent offices, filing really nice applications for your clients. There are small rewards every day.
Thank you. All right, let's go through one more question, and then we'll need to wrap up. What I'll do for the questions that we can't get through, if the panelists are willing, I can send these questions to the panelists and they can send back their answers, and I can then send it to essentially the guests here, audience here today. I see Andrew nodding, thank you. So let's see, what's the next question? I've actually, hold on one moment. Importance of a PhD over MS, I've lost my place. Do you see the next question, panelists? Oh, what do you submit as a writing sample? I assume that's part of an application.
Yeah, I mean, that varies. I've seen manuscripts and I mean, that's pretty common. It varies.
Scientific manuscripts, you mean?
Yeah, yeah.
Okay. All right. Thank you to the panelists, Dan, Andrew, and Mengmeng. To all those who came, thank you so much. You can reach out to us at science@scismic.com. Let me just put the emails here. Whoops, scismic@scismic.com. And that will reach out to our candidate success team. So for any IP positions that we have now, you can inquire about them with our candidate success team. To reach me directly, my email is elizabeth@scismic.com, and you can check out Scismic at scismic.com/scientists. Thank you so much to all of our panelists. I will send the remaining questions to them by email and send up a follow-up email to everyone who attended today. Thank you. Thank you so much, all.
Thank
Bye.
you.